The next matter to come before the court this morning is Victoria Douglas et al. Versus Lynda Harvey Williams. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you want to let me know if you need that rebuttal time or wish to reserve it, I'm keeping the clock this morning. Can keep you apprised of the passage of time. The court's read the briefs and are ready to proceed when you are.
Thank you, Your Honor. May it please the court, Attorney Larry Sheen for the appellants, and I would like to reserve just 2 minutes for rebuttal. As I stand before the court this morning, I represent the appellants, and the appellants have actually changed. The appellants now are one bankruptcy trustee from the Middle District of Florida who represent Rosemary Douglas's case. The other trustee has now abandoned their claim, and which brings back in Victoria Douglas as back into the case as the original party. I just want to make that perfectly clear to the court. Unlike most appeals, I think this is a very limited issue here. The appellee filed a motion to dismiss in the Common Pleas Court based on 12b-6 motion. 12b-6 simply is a motion, is the complaint sufficient enough to withstand within the four corners of that complaint. And it's clear from the ruling of the court that they went well outside those four corners. In fact, they make it perfectly clear that their decision is based on a lack of standing due to lack of injury, lack of damages, whatever you want to call it, from the subsequent months later bankruptcy filing of Victoria Douglas, and then months even later of Rosemary Douglas. So they were not considering the four corners of the complaint there. So they were clearly outside that, and they did not make any notice. If they had wanted to consider this, first of all, as a Civil Rule 56 summary judgment, they would have had to give notice. And in that case, had they considered it as a summary judgment, it also would have been a dismissal with prejudice. And as the court knows, the dismissal is actually without prejudice, so it's clearly stayed within that dismissal of the 12b-6 motion. Therefore, I submit to the court, the judge was bound to stay within the four corners of the complaint, not consider any extraneous information, which the court clearly did. Now, the appellee has made an argument that the court has to be able to consider outside the four corners. Well, it's long-standing law that they can't, but what the appellee has argued, and they use as an example, is a foreclosure case. And I've been on the wrong side of those foreclosure cases before this court, before the Kuchar ruling came out, okay? And they say, well, you've got to have that information, because how could they then later down the road decide that there wasn't sufficient information at the time of filing? Well, those cases are totally different. You can clearly find out down the road, did they have the mortgage when they filed? If they didn't, then you get into 12b-6. That's not the case here. Okay? Clearly not the case here. Damages are for an issue trier of fact. Okay? And a couple points to make there. If the court wants to use this as their argument, I submit to the court there were damages, whether it's the judgment that was issued, jury verdict that was issued. Even if the court doesn't want to consider that, or the lower court doesn't want to consider that, what about the fact that the judgment forced these people into bankruptcy? That's damages. Okay? What it's worth, again, that's for the trier of fact to decide, but that's damages. So as far as not having standing to file at the time, clearly they did. The other issue before the court was a summary judgment motion as to attorney-client representation. And the court found summary judgment against Rosemary Douglas that she was not represented by Attorney Williams. Well, I won't get into the argument I made within my brief. That's before the court as far as direct representation. I believe it's clear. I believe it's clear. I believe I made my argument clear as to why I believe there's direct representation. But even if the court doesn't accept that argument, clearly there was an issue of privity between the parties. And I think the the appellee made the argument for me. If you look at the appellee's brief, they state, privity of the estate creates a property right between an owner and a subsequent owner. Well, that's exactly what happened. Victoria Douglas, based upon the advice of Attorney Williams, transferred real estate to her mother, Rosemary Douglas. We have the privity of property, one owner to the next. It's exactly what privity is.
But we're not talking about a damage to a piece of real estate here wherein I've become a subsequent owner. We're talking about a fraudulent transfer damage, which is an act as opposed to...
But it wasn't a contract issue. They're arguing that it's a contract issue. This is property, and that's what privity is, transfer of a property interest. And real estate's property, what do you want to call it, real estate, whatever, it's still a property interest, and it's the same subsequent interest in that specific piece of property. I mean, that's what privity is. I mean, it's actually the ideal situation of privity.
Well, just, what if the situation would have been this? What if counsel had advised Victoria, you need to get your legal bills paid, and you can transfer this piece of property to someone, although I'm telling you that that might not, you might not be able to do that. That might be deemed as a fraudulent transfer, but that's not going to make any concern of yours because that person will have the property, which may be subject to, for lack of a better word, recapture into a, back to you. See, I can see where perhaps Victoria has an interest in that what was later deemed to be a fraudulent transfer different than her mother in that regard. So you're arguing privity, but could they not have had interests that were not aligned at the time of the transfer and after the transfer has been
No, because
fraudulent?
Under the fraudulent transfer statute, in this issue, you can fight against both the transferor and the transferee. So they wouldn't have different interests no matter how it shook out. But if had she advised her not to do it and she did it, we wouldn't even be here because there wouldn't be any negligence claim. She would have done what she had to do as a lawyer, saying, you can't do it. You've got a problem down the road if you do it. But she told her to do it, and that's the issue here. And they don't disavow the negligent part, they disavow the fact that there's damages here. And I submit to the court, there are damages. So, that's basically what I have. Thank you.
Good morning, Your Honors. Attorney Connie Hightower here on behalf of the App.No, Lynda Harvey Williams. Attorney Sheenice first addressed the motion to dismiss, so I'll first address the motion to dismiss in this case. Attorney Sheenice also represents that this was a 12B6 motion. This was actually a motion under 12B. At the time that the motion to dismiss was filed, the Schwartzwald case, which the Supreme Court used to address standing at the time of the filing of the complaint, had not been clarified by the Kuchta case. So many litigants were using the 12B1 subject matter jurisdiction based on what was in Schwartzwald to file a 12B motion. In this specific case, we did the same thing, filed a 12B motion under subject matter jurisdiction as it relates to standing, as it relates to Schwartzwald, and also whether or not they have actually proved that there were any damages and that they had standing at the time of the filing of the complaint. When Kuchta came out, Supreme Court said lack of standing was certainly a fundamental flaw that requires a court to dismiss an action. Any judgment on the merits would be subject to reversal and appeal. I believe that Attorney Shenice has conceded today that if this were a foreclosure case, then absolutely, if the facts of the case during the pendency of the action demonstrate the lack of standing at filing, then it would be appropriate for the trial court to dismiss it. I don't think this is any different. I think if you have to have standing at filing and your standing is questioned when the filing occurs and then during the pendency of the case, facts are brought before the court to determine a lack of standing, then that is a dismissal. Whether the dismissal occurs at the trial court level or whether the dismissal occurs at the appellate level, lack of standing is still lack of standing, which we believe that they had in this case. Final appealable order of the jury verdict is crucial in whether or not at the time they had lack of standing. Second thing that's crucial is the appellant seems to ignore what they pled in the complaint. The complaint is very vague. It is very vague as to damages. It's also vague as to the privity arguments. Many of the arguments that are being raised here by the appellant were not properly pled in the complaint. When we're looking at the motion to dismiss, we're looking at the summary judgment motion, we are looking to the complaint and what was pled in the complaint to see whether or not there are any genuine issues of material fact or whether or not there was standing at the time of the filing. The damages in the complaint were very vague, were not specific, did not say that they are redressable and that they will be redressable damages. Everything was pretty much vague, which is why the defendant had asked the court to ascertain whether or not there was true damages at the time of the filing of the complaint. So we maintain the argument, we maintain that the trial court acted appropriately in dismissing the action without prejudice against the plaintiff, which when the plaintiff meaning Victoria Douglas, when she does have the proper standing or she does have redressable injury or damages, it doesn't bar her from being able to refile. It hasn't cut her off forever from filing. As to the motion for summary judgment, I understand that this court does a de novo review. The big issue with the appellant's arguments are some of these were not issues that were pled in the complaint, and some of these were not issues that were brought before the court in their response to the motion for summary judgment. Certainly the plaintiff was the non-moving party for the motion for summary judgment and had a burden to attach documentation, evidence, various things from the record to support why they felt that there were genuine issues of material fact. In this case, the only thing that was attached that really had any credence to their response was an affidavit. Another affidavit, this is the third affidavit and sworn testimony that we've had from the Rosemary Douglas in this case, and again, all of the different pieces that she had were contradictory, almost as if it was an affidavit done just for summary judgment. There was nothing else attached to that response which would show that they were entitled to summary judgment on the facts. The complaint pled that Rosemary Douglas was represented by attorney Lynda Harvey Williams. It did not say she was in privity, did not say her daughter was represented and that she was in privity. It pled representation. The motion for summary judgment responded and said she was not represented. Therefore, we're asking for judgment for the defendant, which the court granted. In regards to the privity argument, I believe that it is important to look at that privity of contract versus the privity of property. Rosemary, in her affidavit, she did say that there was, in her sworn deposition statement, she did say there was consideration. Certainly, the parties' interests were not the same, and I know that the appellant cites Schuller, and in the Schuller case, the parties' interests would need to be the same. And here, they're not the same. There was consideration. That consideration was given for what Rosemary was paying on behalf of her daughter, and that was the basis of the transfer of the home. Whether or not a jury decided, without Attorney Williams being present, what's a fraudulent transfer or what their interests were at the time is not at issue here. At issue is that the privity that the appellant is looking at is privity of property as opposed to the malpractice law, which is saying that somebody would need to be in privity, such as contractual privity, where perhaps they're an agent or a representative, or they were given authority by someone else to act on their behalf. Two completely different situations that we do not believe that the privity in which the appellant is discussing applies here. Finally, we want to point out that at no point in time in any case Did they say that Attorney Williams acted with malice? If there is no legal representation where she was acting in a legal capacity towards Ms. Douglas, Rosemary Douglas, then there would have to be malice. And at no point was malice ever proven, said, complaint was ever a part of this action. And so we believe that when you look at the complaint, you look at the motion for summary judgment, you look at the response to the motion for summary judgment, that no genuine issue of material fact existed as to that representation, as to what was pled in the complaint as to Rosemary, and that that was proper. And in regards to the motion to dismiss, we believe that the motion to dismiss was proper by the trial court, and request that this court, if they do not believe that it was proper by the trial court as to if you feel that it's failure to state a claim upon relief, which relief can be granted, that this court has the ability to look at the same information, determine that there are no damages that are pled that have shown to be redressable, and also do a sua sponte dismissal.
Thank you, Nurse. First of all, as far as an admission under Kucha, I think the court is aware the finding of Kucha had nothing to do with finding evidence later. It was just the clarification that they didn't have proper paperwork at the time of filing. That's what brings in the issue of whether they could file, whether they had standing to file. That's the theory behind Kucha. So that has nothing to do with evidence discovered down the road. It's what you have when you file the complaint. So Kucha is not applicable law to what we're talking about here today. And I don't see how, again, a jury verdict, a court judgment, a certificate of judgment filed, actively trying to collect judgment cannot be considered damages. I don't see how the appellee can sit here and say they're not damaged. It's still going on today, even because punitive damages are not dischargeable in bankruptcy anyway. There was a punitive damage award here. So it's going forward. So there are damages. And as far as Rosemary Douglas goes, this is not contract. She was clearly, I asked the court to review the fact as far as the representation, the direct representation, but I also, again, look at the court to say this is privity of estate. This is not privity of contract. And lastly, this issue of the complaint itself. This is a notice pleading state. My complaint was no different than I filed any other complaint. I asked for damages in excess of $25,000. If the defendant at that time wanted more specific damages, it's their duty under the rules to come back and say, well, what are your damages? What are you actually asking for? The rules specifically state that. They never did that. And I did address the fact that she represented Rosemary Douglas. You don't have to get into detail in notice pleading. They were well aware that we were arguing that she represented Rosemary Douglas, she represented Victoria Douglas, and the reason for the representation was the transfer of the real estate. That is sufficient under Ohio rules of pleading. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website and the House Supreme Court website. Thank you.
Thank you.